In this video, I'm going to explain how to obtain power of attorney in Missouri. I'll cover the different types of power of attorneys, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your very own power of attorney. And by the way, if you feel like you want to get help creating power of attorney, I recommend you contact people from lawdepot.com because they are professionals and they will be able to help you. And I'll leave a link to their website down in the description of this video. And with that in mind, let's jump right into it. Understanding power of attorney. What is a power of attorney? A power of attorney is a legal document that empowers a trusted individual to manage certain aspects of your financial affairs when you cannot do it yourself. These financial matters may include depositing checks, filing taxes, or even making decisions about your real estate property. Types of power of attorneys in Missouri. Missouri recognizes several types of power of attorneys, but the most common ones in estate planning are financial power of attorney. This type enables someone to handle your financial and business matters. It's often an essential component of estate planning. Medical power of attorney. In Missouri, this document is called a power of attorney for healthcare. It grants someone the authority to make medical decisions on your behalf. Both of these power of attorneys are typically durable, meaning they remain effective even if you become incapacitated, making them vital for unforeseen circumstances. Legal requirements for a financial power of attorney in Missouri. To create a valid financial power of attorney in Missouri, certain legal requirements must be met. Mental capacity for creating a power of attorney. The individual creating the power of attorney must be of sound mind. While the exact criteria for mental capacity may vary, consulting a lawyer is advisable if you have doubts about meeting this requirement. Notarization requirement. In Missouri, to create a durable power of attorney, the most common type is used in estate plans. You must sign the power of attorney in the presence of a notary public. Additionally, many financial institutions prefer notarized power of attorneys for authentication. Steps to obtain a financial power of attorney in Missouri. Here's a simple guide to creating a durable financial power of attorney that is valid in Missouri. Step 1. Create the power of attorney using a form, software, or an attorney. Numerous private companies offer power of attorney forms or templates that you can complete. For a user-friendly experience, consider using lawdepot.com, which guides you through creating a valid state-specific POA and estate plan. Alternatively, consult a Missouri attorney to create a POA, especially if you intend to include it as part of a comprehensive estate plan. Regardless of your chosen method, the power of attorney creation process typically involves granting your agent specific powers. You can select these powers from a list such as those related to real estate transactions, banking, financial transactions, retirement plans, securities transactions, business operation, government benefits, tax matters, personal and family maintenance, and more. By default, a power of attorney in Missouri is not durable. To ensure it remains effective even after your incapacitation, you must include a statement like, "This is a durable power of attorney and the authority of my attorney in fact shall not terminate it if I become disabled or incapacitated or in the event of later uncertainty as to whether I am dead or alive." Step 2. Sign the power of attorney in the presence of a notary public. Ensure that you sign the power of attorney in front of a notary public to validate it. Step 3. Store the original power of attorney in a safe place. Safeguard the original power of attorney in a secure location that your loved ones can access easily. Make sure they know where to find it, as your attorney in fact may need the original in case you become incapacitated. Step 4. Give a copy to your agent or attorney in fact. Provide a copy of the power of attorney to your appointed agent, ensuring they are familiar with its contents. Step 5. File a copy with the recorder of deeds. If your agent requires the authority to conduct real estate transactions, file a copy of your power of attorney with the Land Records Office, known as the Recorder of Deeds, in the relevant county or counties where you own real estate. This ensures that the Recorder of Deeds recognizes your agent's authority if they need to sell, mortgage, or transfer real estate on your behalf. Step 6. Consider giving a copy to financial institutions. Share copies of your durable financial POA with banks and other institutions where your agent might need to carry out transactions. This step can streamline the process, as some banks have specific requirements for accepting POAs. Naming an agent or attorney in fact in Missouri. From a legal perspective, you can name any competent adults as your agents. However, practical considerations such as trustworthiness and geographical proximity should influence your choice. Missouri permits the appointment of co-agents who can act simultaneously. Still, it's generally advisable to have a single agent to minimize potential conflicts. Nevertheless, designating a successor agent, an alternate who assumes the role of your primary agent, is unavailable, is always a prudent move, as it establishes a backup plan. When does my durable financial power of attorney take effect? By default, your financial power of attorney in Missouri takes effect immediately upon creation, unless you specify otherwise. While you can set conditions that must be met for activation, this springing power of attorney is typically not recommended due to its potential complexities. When does my financial power of attorney end? Several scenarios can lead to the termination of your financial power of attorney. Revocation. You can revoke the power of attorney at any time provided you are mentally competent. No available agent. If there is no agent or successor agent available to act on your behalf. Court invalidation. Although rare, a court may invalidate your document if it determines that you lacked mental capacity when signing it or that you were a victim of fraud or undue influence. Additionally, in Missouri, if your spouse is named as your agent in your POA, that designation automatically ends once either of you files for divorce. To clarify, your ex-spouse's authority as your agent ends, but the power of attorney remains valid. If you designated a successor agent, that individual would assume the role. And don't forget that if you feel like you would like to get help creating your power of attorney, I recommend you contact people from lawdepot.com. They are professionals and they will be able to help you. And for your convenience, I'm going to leave a link for their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.